We appreciate all of the guests who have appeared on our show and sincerely thank them for providing you, our audience, with useful information. However, the advice our guests provide is theirs, and we encourage you to seek out a professional if you have specific questions about any topic we cover on the Crushing Debt podcast. On this week's episode of the podcast, eviction and foreclosure moratoriums.
Welcome to the Crushing Debt Podcast with your host, Florida attorney Sean Yesner, where our goal is to help you get rid of the financial bullies in your life.
So welcome back to this week's episode of the Crushing Debt Podcast. My name is Sean Yesner, owner and founder of Yesner Law, and I have a guest with me on this week's episode. But before I get to my guest real quick, I do want to talk to you all about the sponsor for the Crushing Debt Podcast, Sam Cohen with Attorneys First Insurance. Attorneys First provides errors and omissions coverage, E&O coverage, malpractice coverage, all the same thing, to attorneys and title companies throughout the country. I know that Sam writes insurance here in Florida. He writes insurance in a bunch of other states. If you happen to be in a state that Sam does not write insurance, he will either get licensed in that state or he'll refer you to one of his network in that state. But if you're a title company, if you're an attorney, you're looking for E&O insurance, contact Sam at sam@attorneysfirst.com or www.attorneysfirst.com. Again, Sam Cohen with Attorneys First. He's a friend of the show. He's a friend of mine. He's an excellent, knowledgeable malpractice agent, and that is the only type of insurance that he writes. The other thing I want to do is give another plug to my book, Become Debt Free in Less Than an Hour. You can find that at seanmyesner.com/become debt free. But that is the last that I will talk about me, because I want to bring my guest on the show for this week. He is a partner at Owen, Dunivan, a law firm here in Tampa that does Tampa Bay that does very much a similar area of law to what I practice in terms of consumer protection, consumer litigation, foreclosure defense, a lot of those different types of areas. He does practice in a certain area that I don't really practice a lot in, so we're going to talk about that. He's been an attorney since 2013, and so welcome my guest, Bryant Dunivan. Welcome, Bryant.
Hey, Sean. Thanks for having me.
So I want to talk a little bit about the moratoriums and actually the expiration of the moratorium. So Governor DeSantis here in Florida put this moratorium in place and said we can't, no evictions, no foreclosures. That got extended multiple times. One of the latest extensions said no final action. And then the executive order was set to expire October 1 at midnight, 12:01 midnight, on October 1 of 2020, and the governor didn't extend it, so it expired. So I was wondering your impression, because I know what I think, but I think one of the questions was, well, can I file the eviction? Can I file the foreclosure case? And I think there was some confusion until the governor amended it to say final action. I don't know what your thoughts are, what your take is on that.
Yeah, I was counseling both sides, landlords, tenants, that if you were going to try to evict somebody, it better be for a non-payment default, meaning you're not taking care of the property, something like that isn't related to payment at all, especially in the first 4 months, I think, from March to about July until he amended that order. Once the final action language came in, the final action is pretty clear. That's going for judgment or getting someone out. So I think there became more of an ability to file the actions, give 3-day notice, and say, I'm going to evict you. But that first 4 months, if anyone was doing it, I questioned whether it was even valid notice.
Yeah, and I know some counties here in Florida were putting a total halt on everything, even at the beginning when the executive order first came out. I had a foreclosure hearing in Pinellas, and I argued that we shouldn't be going forward with the hearing itself because it was one of the earlier iterations of the executive order, and the judge basically shot me down and said, we're doing everything up until the foreclosure judgment, and we're not scheduling the sale.
That was the problem, I think, with those orders. It said a lot, but didn't say a lot, too. So it became open for judicial interpretation. And back then, even the District Court of Appeals were shut down. There wasn't a lot of stuff going through the court system. Right. So it was hard to even get judges to, weigh in on what was the meaning of this executive order that just came out.
Well, and I know you do a lot under the FDCPA, the FCCPA, which are the consumer protection statutes. Were you of the opinion that a landlord who issued a 3-day notice in the early days of the executive order, a landlord who issued a 3-day notice or who filed an eviction, were you under the opinion that that was a violation of the consumer protection laws?
Yeah, I think it was. At least from a statutory level, it was mischaracterizing essentially legal status of debt. I'm going to evict you, but my eviction statutes have been suspended. It's not, you're not bringing a breach of contract or something like that. So at that point, it became a real gray area by even using that language in the 3-day notice.
Did you file any cases on those types of facts?
We didn't file any cases, but for someone who maybe had an eviction filed during the moratorium, a lot of times it was pro se folks who were filing it. But yeah, we brought them as counterclaims. Most are still pending through the process, though.
I wonder how they're going to be affected by the final action language and now by the fact that the executive order doesn't exist anymore. But I guess it really doesn't matter if the creditor violated the statute at the time, the fact that it was a violation.
And these are strict liability statutes we're dealing with. It's not like there's gray area. It's the legal status of the debt. An eviction didn't exist in the state of Florida. Our statutes were suspended and everything was told out until a future date. I think that was pretty clear for landlords who were looking at it to, wait a little bit to file.
Yeah.
The ones that did so knowing that stuff was out there.
Well, it was interesting. I had a judge in Pinellas County in Clearwater tell me that even though the executive order said the statute was suspended, the fact that the clerk was still taking cases and the fact that the clerks were still indexing cases meant that the statute, and for those that don't understand, the executive order said, I, Governor DeSantis, am suspending any statute that would provide for an eviction or a foreclosure, basically. And this judge had the interpretation that since the clerk was accepting cases, suspension just meant we're not going to do anything after the case is filed. Where I was saying suspension means the statute, in essence, doesn't exist right now.
Exactly. That's where I was at with it, too. If the statute doesn't exist, you shouldn't be able to file an eviction. And I even got super technical with it and looking at if it was an attorney filing the suit. Well, the e-filing portal for certain counties said, look, we're not accepting evictions. We're just not going to accept that filing. So there was even more notice put on attorneys than maybe put on pro se litigants who walk it into a courthouse.
Yeah.
But it was all kind of coming into play, too, because if that direction's out from a clerk, then even that pro se person should have been given that same information.
Right.
That landlord who's filing their own stuff, buying the forms and filing their own evictions, someone should have told them. If they didn't, they should have looked at these executive orders.
Yeah. And some people may or may not be facing some. And I get it because, like you said, you represent landlords and tenants. I do as well. And so you have the one side of the coin, which is good. We weren't able to evict people that legitimately couldn't pay because of a loss of job due to COVID. But then you look at the other side and you got landlords that are getting slaughtered out there because they're not getting rental income.
And we kind of turn that on the head. I represent a lot of real estate investors as well as part of my real estate practice. And rather than focus on the eviction and focus on the shortfalls, they want the goodwill in the community. Really, everyone was going through a disastrous time with this. So that company essentially grew hard. They wanted to work with people. If you couldn't afford it, let's work it out. We saw, I'll drop the name of your show, crushing debt from it.
Right.
I mean, it's a point where the economy, the bottom basically fell out of it. We haven't seen losses like that since the Great Recession in 2008, and you couldn't go anywhere to eat. I mean,
right.
When have we seen something like that? So, yeah, I think a lot of people understood we're all in the same boat with it, and that was helpful for, a lot of my tenant clients too.
Now, you've been practicing since 2013. Is that right?
Yep.
So that was right at the end of the last recession, towards the end of the last recession.
Yeah, it was right when a lot of banks were holding kind of their foreclosures that they knew it was going to have a little warts on it. It was going to be a little more difficult to get through. And that's when we saw a lot of the older filings. So stuff from 2009, 2010 default dates. So yeah, we were still dealing with those issues even back when.
Right, but so do you foresee another wave coming? Do you foresee another bubble or another wave of foreclosures, wave of evictions? Do you see that coming?
We're preparing for it. I think we're going to see a spike in foreclosure filings, especially, forbearance-based ones. People who took the CARES Act forbearance, maybe they weren't told by who they were talking to on the phone that, hey, look, there's going to be 4 months, 5 months of payments due when this thing's over. Plan on that.
Yeah.
And for people who aren't prepared, that's hard to do. It's hard to come up with one mortgage payment some months, let alone 5.
Right. I'm wondering what I've always been thinking. So I went through Hurricane Irma as well, which was 2017, if I recall. And I took advantage and I got a streamlined modification based on Irma. I wonder if, and Irma was limited to Florida and the other states that were impacted by Irma, but I wonder if at a federal level, we're going to see that kind of streamlined modification because that's what a lot of people don't understand is that a forbearance plan doesn't necessarily catch you up, keep you current. It's just the bank forbearing on taking foreclosure action or whatever. I wonder if we're going to see some kind of streamlined program rolled out nationally.
Oh, I imagine so. There's going to be a response to it, especially from, the major banks, the Bank of America's, the Regions banks. They're all going to try to roll out something because they don't want the homes.
No.
They want to get paid. They look at it as these are our clients. We want to work with people so people will continue to do business with us.
Yeah,
It's the situations where, you've got someone on the line saying, hey, don't worry about it. You're current, and kind of not describing it properly. I think that's going to be a lot of issues. And there's people who it's based on principle at that point. I shouldn't have to pay this much money. I was told to not worry about it, and now I have to worry about it. So
or
it becomes principled for some folks.
I think the important point is to reach out to someone like Bryant, reach out to me, reach out to our peers rather than, trying to do this on your own and saying, I was told that it was a forbearance and I'm not going to pay out of principle. Before you go down that road, reach out to one of us. And by the way, I do want to give Bryant's information. And so the law firm is Owen Dunivan. And so you can find them at owendunivan.com, OWENDUNIVAN.com, or you can contact Bryant by email. It's B as in Bryant, B Dunivan at owendunivan.com. So that's his contact information. And I think where I saw a lot of people getting into trouble, which I think you mentioned, is they got upset with the banks. They got upset with the situation, and instead of reaching out to someone like you or me, they tried to go it on their own until the foreclosure was filed, and then they come to one of us and say, help. But I don't want to put you on the spot. I know I do free consultations. I don't know if you do or not, but I would say reach out to one of us first.
Mm-hmm. Yeah, we typically do, especially if someone's just been served. A lot of times, back in 2008, 2009, folks were going through this, not taking notes, not taking who I talked to, their employee number, time of the phone call. So if you are going through that, make sure you're taking down those details, because if you don't get with us immediately and you do get served, it's good to have that information. They say most of the calls are recorded. I like to be able to discover that information if we're dealing with a lawsuit.
I don't know that the sunset of the executive order, I don't know that the termination of the executive order is really going to necessarily open the floodgates yet, because we still got the CDC out there saying no evictions, and we still have the CARES Act saying no foreclosures on federally backed. So
right.
I don't know that the floodgates are, it's interesting, the people that criticize DeSantis, the governor, by saying, he's allowing all these evictions and foreclosures. Well, that may be true, but we still got the CDC protecting some people. We still have the CARES Act protecting some people. And
it's unfortunate, too, because when you do a blanket moratorium like we had, anyone is trying to fit under it. So you have people who don't necessarily fit that hardship who are trying to use it. And, that's not necessarily fair to the folks who really are feeling the hurt from it. So I can see to a large degree why, at least the state government is now deferring to the CDC. Their declaration's pretty specific. It's got an income requirement. It's got, you have to basically sign under penalty of perjury. These are the issues. And now you're dealing with strict guidelines, whether you fit or you don't, rather than, making that argument in court and relying on what a judge is going to do.
So I want to switch gears a little bit. and talk about some of the other areas that you practice. Now, I understand RESPA, the Real Estate Settlement Procedures Act. I understand the Truth in Lending Act, but you've been using them as a way to fight the foreclosure, as a way to get a better result for your client. So most people know RESPA as an origination statute. In other words, governing the way that the banks have to originate loans. But RESPA also covers the way that they service the loans. Mm-hmm. So what are some of the things you're seeing under RESPA that people may want to look out for and call you about if they're in a foreclosure situation?
So the biggest thing with RESPA, probably my largest referral source under both the RESPA and the Truth in Lending Act, is the payoff statute. Basically, if a title company or you request a payoff from your lender, they have 7 business days to give you that payoff, generally. If they miss it, like we were seeing a lot during the COVID time period, that could be a statutory violation, and it's a way to either increase leverage when you're dealing with, trying to do a short sale or a foreclosure or, fight it, or to just try to make sure your bank's doing the right thing. If they miss that deadline, what else are they missing? So a lot of people kind of looked at it as a measuring rod of how the servicing goes. The forbearance that you brought up is people are doing modifications after that forbearance expires. There's a lot of specific timelines on how to apply for loss mitigation, whether it's a loan modification, potentially a refinance, or something related to the servicing of the loan in that application process. And the deadlines are really strict. Once you send in your initial financial package, you should get a notice back saying, look, we got your package within 5 days. If they don't, it's a violation of RESPA under Regulation A. That's the servicing rules that kind of kick in once you're communicating with your lender that way. Now, there's a lot of specifics with it. You got to send things to the right address. But if people feel like they're getting spun around trying to apply for a loan modification or see what their other options are with the forbearance, that's been a lot of our calls lately.
Does RESPA...
The banks still don't know what really to do with it.
Yeah.
They're still coming up with this process. And
Does RESPA only apply to the one that signed the note, the one that signed the mortgage? I mean, for example, you and I have a case together and are sort of on the same side. You represent the homeowner. The property ended up going to sale. It's my client ended up buying it at the courthouse steps. And so right now we're both sort of trying to get the sale unwound. And I think you have a good argument to do that. We don't have to discuss the case in particular, but the reason I bring this up is I've had a situation where this particular investor has bought other properties at homeowner association sales. And what a lot of people don't realize is you've got a first mortgage out there. Now, the Florida statute allows us as the property owner in a different case to file with the bank and get a payoff letter because we own the property. So the bank has to send us a payoff. But if they don't, can we use RESPA to squeeze them as the third-party bidder when we're not the one whose loan is being serviced?
Right. And a lot of times RESPA kicks in anytime there's a federally backed loan. So even a buyer, if they're paying off a federally backed mortgage, may be able to make those arguments because RESPA is supposed to kind of give you that streamlined process on a federally backed loan. Will it work in court? It depends on your circuit, really. I mean, the 9th, maybe, you maybe have a shot depending on your judge. The 11th, maybe not. So it really depends how you're kind of teeing up the issue. The more errors that exist in that process, I think the stronger the argument becomes. RESPA's the statute's changed so much in probably the past 3 years where it's hard to get past the old case law. There's so much of it that just dealt with origination. You got to turn that corner in a judge's mind and even, the defense bar saying, no, this is a servicing issue too. And now you have violations of it.
Yeah, and I think not to criticize our judiciary, but I think some of them may not understand that RESPA is also a servicing issue rather than an origination issue.
It's a recent change, yeah. When Regulation X came out, it basically rewrote the statute, but it's not in the statute, it's in the federal regulations. So it's hard to kind of quantify the old case law with it. Okay, you didn't get proper disclosures, or there was a possible steering issue to the title company you're using. And now, they didn't give you a payoff, and that can be a violation of this origination statute. It's changed a lot of books I rely on when I'm dealing with, RESPA issues from like the National Association of Consumer Advocates. I've got their whole library here. And as soon as that came out, we got a new revision. It rewrote a lot of material here.
Wow. What other issues are you seeing out there in terms of FDCPA issues, FCCPA issues, RESPA, TILA? What else is going on? What should people be looking for?
Well, anything related to debt, whether it's an auto loan, student loans, how they've been told historically their loans are treated, now they're finding things out differently. They may be applying for forbearances or help under the CARES Act, and they're not getting it because it's not really a federally backed loan, even though they believed it was the whole time. We're seeing that a lot on the student loan front. We've seen probably 2 or 3 instances just recently where they thought for their whole life of the loan that these are federally backed. I have a federal student loan, and they're not because they get no treatment under the CARES Act. So that's a big issue we're looking into now, pending litigation, dealing with how debt collectors are representing that debt versus how the debt is actually being treated by different entities, and we're finding it just to be off. So if anything seems off, that's a good way to get in touch with an attorney just to make sure the T's are crossed.
Yeah, and
you don't want to think you get the CARES Act versus you don't, and you miss these payments, and now they're due.
Right, and you're bringing those arguments under the FDCPA and the FCCPA, right?
Yeah, we're bringing it basically how they characterize legal status of debt, or we filed a student loan case where we're dealing with, is it backed by the Department of Education? No, it's not, at least based on what the servicer is telling us now. Their phone calls say it is. So are those phone calls, are those inherent, attempts to mislead people to collect debt because the government's coming after them? I don't know, but it sure seems like it.
Wow. And so I want to give you, I understand, but for purposes of the audience, I want to give you an opportunity to also explain. We talk about the FDCPA, the FCCPA. You want to explain those statutes in a little bit of detail for people that don't understand it?
Yeah, the primer I give, the Fair Debt Collection Practices Act, that's the reason, you get the mini Mirandas by, you get a phone call, this call is from a debt collector, any information may be used for that purpose. That's the statute where you're getting all those kind of disclaimers on phone calls when you're dealing with debt. That applies to debt collectors. So someone who's maybe taken over a debt on behalf of Bank of America or a larger lender. It's a very strict statute. There's not a lot of defenses to it, where you're dealing with pretty much all forms of communication regarding collection. So whether you're getting a letter or a phone call, those can all fall under the purview of that statute. That's at the federal level, but at our state level, we have the Florida Consumer Collection Practices Act, which is a much broader statute. It applies to any person. So even if it's the original creditor, it may still apply, and it expands on the Fair Debt Collection Practices Act.
Right.
So basically, those two statutes, you can almost work them together to find violations that may be there. And a lot of times it's, the frequency of phone calls or, the letters you keep getting. What's on the envelope even matters. So it really tries to curtail offensive collection action.
Yeah. And so the FDCPA, the Fair Debt Collection Practices Act, that only applies to the debt collection companies. So
correct.
If someone owes me a consumer debt, and they owe me personally or individually or whatever, and I go after them and I violate the law, there is no violation under the FDCPA because I'm the creditor. But like you said, the FCCPA, the Florida Consumer Collection Practices Act, is more broad, and so that would apply to me as the owner of the debt. And so sometimes that also determines who's in the crosshairs of the lawsuit as to who was committing the violation. Right.
But at certain times, you can argue that the original creditor is actually liable for it. It's called vicarious liability for the legal nerds listening in. But
right.
We're making those types of arguments because the Fair Debt Collection Practices Act and our state version, they require truth when it comes to collecting these debts. And if the information is not being passed properly, whose fault is that?
Yeah. No,
not my job to figure that out. That's what the judges are there for. So,
but again,
or the jury in most cases. Yeah.
But again, the issue there is, reach out to Bryant, reach out to me, reach out to an attorney if you have a debt collector that's being overly aggressive or misleading, or even if you're uncertain, if you have a debt collector calling you about something and you don't even know, do I owe this debt? Or even if you do owe the debt, again, reach out to one of us and let us make sure that they're going about collecting it the right way. Because maybe if there is a violation, we can use that. Now, they only get $1,000 per statute, plus any actual damages we can prove. So if someone owes $20,000 to Wells Fargo, and Wells Fargo sends them a bad collection letter, it's not going to necessarily wipe out the entire debt, but it's something with teeth that we can use in terms of maybe settling it out, or maybe the violation is bad enough that we can bring in punitive damages or something like that. But my point is, there's so many variables. Give Bryant a buzz. Give me a buzz. If you have a debt collector coming after you, aggressively or otherwise, let us know. There's always different ways that we can help.
Yeah, and the case law changes every day dealing with these types of claims. I mean, we had a Supreme Court case come out, I think it was last year, maybe the year before, Spokio. It was the seminal case for debt collection statutes that changed how the federal courts are looking at standing, whether you can bring that lawsuit. And if you just think a technical violation of the statute is going to be enough, it may not be, especially under that statute and what's been coming out in the 11th Circuit. So you definitely want folks who know what they're doing, because each case that's not brought properly, or you don't have the right facts, could lead to bad law.
Yeah. So again, the point here is reach out. So again, I'll give Bryant's information. The firm is Owen Dunivan, the website owendunavan.com, and again, I'll put it in the notes. So if you don't catch the spelling, it'll be in the notes. You can catch it there, or you can email Bryant at bdunavan@owendunavan.com. And so again, reach out to one of us just to make sure that your rights are being protected. And again, even from the landlord side, even from that angle, give us a buzz to make sure that you're going about collecting in the right way, that maybe you can be insulated against these types of claims because you're doing it in the right way. So as we sort of get to the end, Bryant, anything I missed, anything you want to add?
Yeah, I mean, my practice is more on the tenant side. So anyone who's dealing with these issues with landlords, let me know. I do represent investors, but I'm not filing many evictions. Also, I'd extend it to other lawyers. If any lawyers are out there listening to this podcast, you've got questions, need an ear to run it by. I know in my career, I thought I've had great cases. They weren't great cases, and someone kind of set me straight. So I'll make myself available for that too. It's definitely good to have a community when it comes to bringing these types of claims. And if you're going to do something, I don't want to do something that gets used against us in California, for example. So reach out.
Yeah, no, and that is one of the things I miss as a solo. Bryant, you've got a law partner. One of the things I miss about having law partners is just that ear to run it by. So, yeah, good point. So, with that, I think I will end this week's episode of the Crushing Debt Podcast. Thank you again, Bryant, for being a guest on the show. I appreciate it.
Thanks, man. Thanks for having me.
Yeah. And so, like I always say at the end of every episode, I hope that at the end of the month you have more money, rather than at the end of the money you have more month. That'll do it for this week's episode of the Crushing Debt Podcast. Go visit our sponsor, Sam Cohen. Go to SeanMYesner.com/become debt free to get a free copy of that book electronically. That'll do it for this week's episode, and we will catch you in next week's episode of the Crushing Debt Podcast.
If you have questions that you think would make a great topic for a future episode, please email Sean or connect with us on social media. Sean Yesner and Yesner Law, PL, are Florida licensed attorneys. The information contained in this week's episode is not a substitute for legal advice. Your situation may differ, especially if you are located somewhere other than the state of Florida. If you have questions, please contact our office or contact a local attorney. Thank you for listening to this week's episode of the Crushing Debt Podcast.